8 weeks. What do you?
So the instance that is the as it relates to the notice confusion. First is this guy not he also did the time of wrestling with the history of the as well as and so also is how is related to the motions of itself, which is there's nothing in this individual that's called it's really to matters. It's pretty serious with from everything to really from so really for long years and I think it is recent that asking what is that I know now based on my understanding, all the evidence, if I can get it, saying possibly I can see it, that is not strong. So I guess first thing I understood like very close to the industry. I just want to think that everything without okay, I think it's right. This thing is like the other side. So I usually state that that's pretty good. When regards to the motion the state responds right? First, it will be so I'm not attacking this. I know before the change that's been overcome. Now, all of the in this case came from this individual. I could, I could not find everything. Not particularizing so one laptop, like every based on the report. So based on the simple search, they got all the other ones who want to search the wrong setting. Because this was wrong, but this was chosen. Help they got that I don't know how to do that. So I'm not thinking because I don't know this stuff every single day. Items were found in whatever engine. Here you say this because the those yes. Jordan, this is you know, also, there were. There's one side, most of the areas that I've so, this idea that all this strong out of that's not so everyone so that's why I'm struggling. I don't do how to play defense against this note. I don't go sit with it. But, you know, that's not sure. Not sure how it's escaped. So, what the folks a black book bag document. And a document. It's still in my experience. I'm not stipulating that I don't make it. That's what I'm saying. I don't know. We try, everything's done. They can do it. I'm not saying when I would do things when it's not being specified, but whatever we can talk about. So, we trying to finish. So I'm trying to move on. What are points? So, SW03027, which was signed on July 8th, 2023. SW03056 also signed the same day for 9/8. BW03715, which is fraud, which can be evidence of truck search, investigation. Yes, another warrant, BW07529. SW050, which relates to silver and black ETHC. SW03191, SW03256, all of those ones relate to the silver and black shade. SW0300519 and SW03090, which relates to cell phones collected. SW03050 relates to scan distance fraud. And SW01938, which relates to key submits. And to make it clear, once again, I'm not trying to suppress the arrestment. I'm not trying to suppress it. The state is to be a broker, if you want to good, so that, to make it clear. And now, the arrestment must be a valid warrant. What I'm saying is, you have to address it to get to the arrest, which has to search, which has to everything else. And I wanted to say that I think this other issue, so it's like to say that some people look at and see it's really evidence in terms of that are acts in count one. And acts started with that something massive for this. That's what we're talking about is president, how was illegal, the search for the car was illegal. Everything's down in that illegal search. Let them on this investigation. Now, the state told you that they got all this other stuff, beyond. None of that happened. So they legally searched the vehicle, legally got his evidence, legally went to their houses and stored it. It all started with the arrest. All started with the illegal search. The issue here is the illegal search. It's talked about there's an arrest, and there's everywhere else. Yes, there's an arrest. Yes, there's battle. Search is the problem. Because the search is illegal. Everything they got from it happened. The other everything from all that information is illegal. And this illegal acts and charges. They are not meeting this. Now, what I did on the book is I did turn over the search. I did turn over the search. So, because those are the last 25 seconds, I didn't turn over. So I just kind of the double computer accounting for the set on the center and then you see that they're not where it's basically there's so I think the book documents in the book But I don't, again, I don't believe us. So,
All right, so we try to understand my. I believe, Mr. Hogan, you were saying that suppression of the impound search of the 4350 is not necessarily leading to suppression of the if the impound of the truck, that's found legal, then it would not suppress. So let's deal with the impound of the truck. Let's deal with the impound of the truck. Then we can have if it's legal impound and legal search, then you all can have what came out of that search. What evidence, as we say, is the fruit that Williams tree. Because what I think Mr. Luke saying is that's not a fruit of that tree. I believe the supposed side of the tree is poison. Before we know what fruit to try. So if we could start there today. I read the motion. Anything else, Mr. Luke, you want to add? I'm sorry, Mr. Luke, on the other person.
no, I just like to go.
Okay. Any witnesses that may be called? Yes. Thank you.
Any, based on the investigation,
Yeah, so after I ran the recycling truck, I started doing a little investigation into because it was a property that was, need help at a residence that was not in the police. So I found that Regina and Mr. Williams, they did have a police house in that he had taken their motorcycle, Harley Davidson, and a trailer. And that, so there was that report of being strange. So looking from the road where I was, I could see very clearly Harley Davidson's a pretty, iconic bike. And I was able to see that it was the same description as what was in the police report, the same police report.
and then the other one, so, that's what it's going to be last. Find out if there's anything going on there.
So we lived in Washington. I was able to eventually get into Olivia, and she had said to me that if I had been taken by Mr. Williams, and then she later did go and file a police report with Cobb County, for that.
That was after.
Yes.
And then did you ever see about more than how did you come to see that?
So I had found through the investigation that Mr. Williams was trying to make the fight. Again, I was on patrol, so I called the service as my first job and priority. However, any kind of downtime that I had, and also have partners, the ones who had options to do that. So
And remind me, we made this, you can determine who the law that was, that's true.
yeah, the white previous was registered to white really strawberry, but he was the one's white.
You're not, with 30 strawberries and anyone.
So for the Pine Grove residents, yeah, so it was listed for, Ernest Williams, Shirley strawberry, about a Shirley strawberry.
And did you have any information, did you testify that the land was going to be punished? Is that the information that you somewhere else?
I did not have information on his wage or anything else. I did find out that they had previous residents, 21 and 55 Bench Street, which is Alpharetta. And they had them in there, but they had signed a lease in March of 2022, so that was what we're doing.
So what
with our location, this is where we're going, you get behind, we go ahead, make the traffic stop, I got some cars between. Mr. Williams actually then pulled off the road into 1007 West Street, which is where there was the Domino's and some other little businesses in there. And we pulled the truck into the responding parking spot. And by the time Officer Yachchenko and myself were able to pull into the parking lot, we just pulled our vehicles behind the vehicle and Mr. Williams had gotten out of the car. And he was taking a picture of something where the property where it's all. I got out of the patrol car. I already knew who he was, but I went ahead and said, Mr. Williams, and he said, yes. I said, sir, I have an arrest for your everyone to your left. And I said, at that point, I said, Mr. Williams, you have to be up there. Once he's in custody, I then transferred him to the Royal Police Department, which is not, I wouldn't be talking from where he saw and he was taken to custody. Sending to protect, but into interview. Detective So Detective Dominguez, he was impacted in session investigation at the time. I had done kind of like training with him on another case where so I hesitated an incident of him in the police department and I started seeing everything that was going on. I didn't recognize the something I said, I think we have in here. Will you work with me? Because I was on the patrol. So he looked at everything and he said, I absolutely think we have something in there. This is supposed to be good. Wrong. And then the signature line on that lease was signed as Shirley Strawberry. Well, Shirley Strawberry is not the wife of Mr. Williams. And then Mr. Williams signed it. There was another form that under Blackbird is really that was submitted. And on that form, there were multiple names, Shirley's name on it, and it was Schwab. So I think the way that was read was at the top said Blackbird Radio Shop was leasing it into that. And then on the Blackbird Trust Radio before was Mr. Williams' name, there was Shirley's Strawberry's name, and then it had, I believe it came over that had documents from the testimony. I think it was like a Jack Relford and then Fulton County. And so those are the names that were on that.
So Blackberry is going to get fixed. Did you investigate what happened?
So we started investigating it and we could find nothing to show that it was legit. It was coming in as a nonprofit. I remember running the business number, the NIN for it, and it came back with coming from the Tennessee. And so all of that was not correct. Knowing the documents as well, we also then had to that was turned over to us, which
So you said that there's EIN on the paperwork, these documents, that's supposed to be, and it was not. So there's fake doc. And then you mentioned the name Angelo. Can you tell me about that? Tell me more about it.
So Candy Relaford was not the real name, the real individual is Erica King. She is the one who dealt with Mission Fulton. She had stated that she was running the houses on behalf of her clients who were, and that she was have that information. She was 1999, which was next door to Mary King.
When you say that Erica King dealt with Mr. Cole, was she dealing with him as Erica King or as Candy?
As Candy Relaford. Correct. She had many years as Candy Relaford was one. And that's who she was dealing with. Mr. Cole has been helping with.
And all this prior to the last set.
Yeah, correct. And then she was also, so the other part was Mr. Cole, that he had created the rewriting and song, who was the real estate agent, and that he paid $1,000 to help get someone to rent his home. Well, I continued the investigation, realized that the phone number was the same, and during this time, and that Tammy Strong was also another previous that Erica King had, so she was not only saying, I'm getting the things for the person, but she was also trying to real estate and getting the money to bring the company.
When you say the telephone, you say the documentation or another, it's also a number for Candy Strong.
There was no, yeah, and that's how we started figuring out that it was exactly phone number and searching.
And you started to mention the system at one point to send to Mark Cole.
Yes.
What, you looked at that letter, who did it report to the sent by?
It was sent by Bulwark Sutton, LLC, which is a law firm, and at the time, trying to remember what the attorney's name she put on it, but one and the last name is yes. And basically, we contacted the attorney, and she said I never signed it. And she would have been associated with Bulwark Sutton. Now, when we looked at Bulwark Sutton online, the website had pulled images from other websites, and there was some parts of the website that weren't even finished. And so we were like, okay, something is up here. And so then later on, we found out that she was then taking another attorney as the Holloway, where she actually sat on for having the Holloway as well, but she never recognized the
We just got the Apollo, that happened after to us, through knowledge.
Right, we started finding out about April Holloway. I did find the first mention of April Holloway came off the Sandy Springs report because after Regina's amendment had filed with Sandy Springs that Mr. Williams was taking the body.
One day when we started out, and you say the same thing, we're talking about. And the previous that project, and the whole. And then report stolen.
Yeah. And so there was a letter sent, a certified letter sent to their residents. And the letter that was sent was actually done by Bulwark Sutton, but now the attorney needs to hold this. That's the first time he actually heard that it was a Holloway, and now we've got two attorneys, and that's what led to further investigation into April Holloway and use of that
So to be clear, everything you just talked about, with the exception of some of the alcoholic stuff, was all ongoing active investigation on July 17th. So let's go back to July 27th, or July 17th. It says about all employees out of the on the detention like that. When you arrested and took you to the station, let's set the time. In the time you made contact with her in that parking lot, how long was it before you were arrested?
Maybe 45 seconds. I mean, I literally pulled my car and I knew we had a warrant. And so I literally pulled my car and I got out of the car. I walked from my car to the sign where he was standing. And I said, Mr. Ernest Williams, and he turned around and looked at me and he said, yes. And I said, "Come for us." I took him in custody and then, very quickly and honestly for policy, we have to do a pat down research before anyone is put into it. So we did search him and then we put him in the box and then transport him to.
It's fair to say that it's something that's
Yeah, probably, and maybe, then whenever, kind of, when we, arrest, when we're taking someone in custody of on a warrant, we always call through dispatch, to make sure that everyone is active and that we can actually bring them in, individually. So, that's also part of that process. So sometimes, that might have a couple minutes because we have to call and confirm the warrant. And so we can do that, but that is absolutely everything. Yes.
So you did that, let's go back to when you returned to the police station. It's Mr. Williams, you did that time.
Yes.
And then when you got back to the police station, what was that?
I immediately said to Dr. Ernest that I have these feelings for you to return to you. And then we started talking about the
And when you were arrested, what did you initially, what did you do with that?
I immediately lost it, cigarette. And I needed to, I actually tried to call the detective given on my way so that I could speak with him on the vehicle. And when I got to the station is when I didn't get to speak. So I immediately got to the station. I told him to go and restrictions from interviewing, which is for anything out there that like keep out and then
And the truck remained.
yeah. Yeah, I'm sorry.
And so you did that, you talked to them, you had a conversation with them about the truck.
Yeah, they just that's when that I brought him over and that truck I had to walk him
And did you have any conversation about what you had? So,
yeah, immediately detected things that we need to totally people for investigative purposes. So we would immediately go back and found it on an investigative ready to document the back lot and do the person to go.
At the time that you arrested Mr. Williams, when you said there was police to be able to
Yes.
how many sets?
There's one.
And based on your training experience, how many sets of police do you have? Do you have any knowledge of where another set of police
No,
So, have a conversation, really sense of how we got to that. Is that what happened?
Yeah.
Can you kind of walk us through that? If you recall, you were
So I basically, I was the police, and so at that point, because I hadn't been in custody, I was sitting with him. And so immediately, as I got back, texting at this conversation, and I say, texting, really, let's go ahead and go back here. Officer Shango immediately went back to the vehicle. He we at that point, for our policy, did a very basic inventory of the vehicle, and waited on the tow truck. The tow truck then took the vehicle back to the Rockville Police Department, after that change of all of it, then placed into our back lot where it was secure. At that time, it was where it stayed until we obtained the tow truck.
And so at the time, prior to you actually being the time that you placed this one under the you investigated all these various times, simply driving the vehicle, seeing the vehicle at the residence on our bureau. Did you believe at the time you placed it under the you have probable cause to consistent times?
Absolutely.
And can you explain to articulate what that was?
I believe it's based on the fact that he had multiple warrants for harassment things like that. He had done a lot of investigations, so a lot of white collar job is documents. And so he was coming from the house, he was obviously going back and forth, he was living at that, supposed to be living at that residence for duties, which is where, people were out for their belongings, and he's transferring belongings that are being there. So yes, we absolutely believe that we had probably cause for the items being.
And fair to say that it's on their investigation to that point. You had knowledge that Mr. Williams had been in justice.
Absolutely.
So let's see that as kind of one of the lines of demarcation. I'm going into this. So kind of talk about it. Part of that. Did you independently have any opportunity to speak to Mr. Williams once he was there?
Yes, Detective Billy did. I was watching on the screen, and then, everyone came along and had a very brief chat. And Mr. Williams he didn't really want to speak. It was more time and basic housekeeping stuff. And at that time, he wanted to get $100,000 before he went for the jail. Something, to be honest, with most people that will absolutely do, so they have a phone number. The detective went in, asked him, if he made enough receipts or something, he said no. And then get in the phone. And so, with consent, Detective then asked him for the password within the phone in front of him, and she had two phone numbers that he wanted. The first phone number was his wife, Shirley, and the second phone number that he wanted was the original, but he wanted to change his phone number, Eric King, and then they just did a little bit, she actually just
You said you knew that.
correct. And the number that he asked for was the same number that he was seeing in the investigation released.
Is that the same number? And then did Mr. Williams ever say anything at all?
Yes, he had made reference to Detective Billy that basically he was like, they were about talking to people to like things about head. And so he made reference to those documents. We had also seen that there was suitcase and multiple bags in the car, which were in Plainfield. So there were multiple items within the vehicle that were, a suitcase is one of them, that would be one piece that some stones in our shop.
And this one, on the video, did you ever open any of those bags? And it's all like the medicine, it's like other than medicine. So we search other than and then let's just talk about a bag. There
There was a little bag that Mr. Williams said, I I don't know what medicine is for, to be honest, but, he mentioned that there was medicine that he took daily and that he needed it. And it was in, and the researching part of it was like, I got almost like a little, very small backpack. And he said medicine is in that bag and that it was on pharmacy. So we asked for consent to take the vehicle, grab it up, get the bag of his medicine, and that's exactly what I did. I walked to the vehicle, I opened the front door, took off the front seat, and I just took the entire bag up and took it to him so he could get the medicine.
And to be clear, there's a request.
Yes.
Yes. We want that invitation. We take a look at that document, and that's how we work confidence in the document. We recognize that document, so how.
Yes.
And document that you have there in front of you, did you personally swear out? The document that you have in front of you there, is it a copy of that?
Yes.
And does it appear to be a fair and accurate copy of the search warrant you're looking for?
Yes.
Does it appear to be a new authorization?
Not that I can see.
Right, actually take a minute, look through it, and let me know if it appears to be. Or any kind of, new states. This is the search warrant. There's a fair standard, actually a couple documents here, the warrant, so there's the affidavit, the application for the warrant, and then there's a determinant that you fill out after search. And looking at the search warrant itself, you see on the second page, the search warrant is signed by the judge. What judge is that?
But the judge that was convicted, and it was signed, by the 2022 at 2:44.
And why 2:14, approximately how long was that after the
So it's probably 24 hours. It was approximately 24 hours. I don't remember the exact time it's been tested, but I know in the afternoon, it was approximately around 15 to 18.
And so I want to move into the affidavit itself. Just a couple very brief questions about that from you. Looking at the affidavit, we've got some numbered paragraphs. See that? And can you go all in the detail about this numbered paragraph? And do you see with paragraph 18, mentions when the economy is related on like saying yes and everything.
Yes, I see.
Okay. And as you wrote this affidavit, it's fair to say it's another kind of off.
Yes.
And so it's also fair to say that paragraph 1 through 17, all the information contained in 1 through 17 you obtained prior to the 7. And then when was the actual search?
The search of the vehicle was conducted on the day.
So same day.
Same day, we basically got a search warrant, it was signed, and got evidence that letting this go, that was first one needed.
And, what would you document what you found in the book? What did you?
So on the card sheet, we have a black bag of documents, silver and black track computer, a full iPhone with document cover, a scan disk, 32 gigabyte USB drive, and keys to a 2002 Vito Liberty, which is from Harvey.
And then once all that, market, where was it?
So evidence was placed into, or was put into evidence. The book bag was secured in the special investigations office, where it was photocopying and then it was placed into evidence. And then the computer and the iPhone, all of this were put into evidence until warrants were taken for those, for them to run to Fulton County for their download report with forensics.
Okay. And all of these items, this is your knowledge, this is on the history back then.
Yes.
Interesting.
Yeah.
I think it's on. You said you gave it the police department for 4 years now? And I guess when you started,
That's correct.
when the police academy, they taught you how to do various phases of the right? One of the phases of the investigation, right?
That's correct.
In regards, regarding investigations, you were taught how to write your report based off of your investigation, correct? You were taught that you had an obligation for your report to be correct. You were taught you had an obligation for your report to be accurate. And you were taught you had a right, or you had an obligation for your report to be complete. And that's important because not only are you relying on your report, but everybody else, right? And you did write a report in this case, correct? And it was a complete, truthful, accurate report. Meaning everything that was important in your investigation was reported. Now, you were taking now that you were controlling back during this investigation. You said your zone was zone B, Marvel.
On that day, it's in case.
So on that day, it was. Now, they thought that you completed an accurate report. On July 7, 2022, that's when you talked about it.
That was one of the days.
At some point, you put your report, you should be left for it. And then you came back again. And as we drive back, that's when you saw the one. And you noted in your report that, that vehicle was registered to the car. I'm sorry, because of the
No, that's fine.
You also noted in your report that Ernest was the one driving. Now, you never memorialized anything in your report that Shirley saw her. You never memorialized anything in your report stating that that F-250 was involved in some type of crime, right? You never memorialized anything in your report stating that you witnessed Ernest Williams commit some type of traffic violation. And in your report, the only one, when you're speaking of this day about the arrest, the only report, also the only one that you put in your report was BW 0328723, which was the Roswell section, correct?
I would like to not remember what that's. That report that day. Well, I have, you know, I worked so long, with a lot of warrants, and that's what I'm.
So my specific question was, if you're completely truthful and accurate report, and we memorialize seeing Mr. Williams and the F-350 that day, the only one we memorialized was Steve Harvey Morning Show.
But then I put that in there, but the memorialized earlier, the warrants passed, and realized, well, I don't remember what was in my mind that day. I would say we probably went to the Roswell one, because that's where I worked, but there were other ones that we listed in that.
And it's interesting to say you don't remember what was in your mind. I think that's why when we talk, the report had to be completely accurate. Right?
Absolutely.
All right, so you wrote down what's in your mind.
Okay, so yeah, we had one for Roswell, memorialized before that, because we had multiple ones.
Thank you. Another time you got to Mr. Williams, you already out of the split. He was walking around the parking lot.
That's correct.
I think you said he was taking pictures of a lease sign.
Yes.
So the vehicle was not moving while you got it, right?
No, it's not moving.
The vehicle was parked, right?
That's correct.
You had memorialized in the complete accurate report that vehicle was obstructing the flow of traffic on the street.
No, it wasn't.
You never memorialized in the complete accurate report that vehicle was obstructing the flow of traffic on the parking lot.
No, it wasn't. Even if I was-
You never memorialized in the complete accurate report that vehicle was causing any type of any behavior on the street or in the parking lot.
No,
And you said it was being parked in parking lot.
no,
And you never memorialized anything in the report stating that the owner of that lot said, hey, we want you to move that vehicle.
no, it's been 6 months.
You never memorialized anything in the complete accurate report saying the owner of the building wanted you to move that vehicle.
No,
You never memorialized anything in the complete accurate report that you sell any type of drug on this board.
no,
You never memorialized anything in the report from another officer or you just you never memorialized anything in the report stating that you believe that the order is running into this type of drug is operating exactly. You never memorialized anything in the report that another officer believed in the drug. You never memorialized anything in the accurate report that you believe there was drugs in that truck that is arrested. And you never memorialized anything in the report that another officer believed there was drugs. You never memorialized anything in the report that you believe there was drugs in the objects that actually believed there was consumed drugs. You never memorialized anything in the report that the other officer believed there was drugs in the objects and that you consumed drugs. Correct? You never memorialized anything in the report that stated that we would look like we would get to the drug for a really hard to be the rest of the drug. I believe you should have had your people with the rest of you never memorialized anything in the report saying you smell the smell of drugs inside the vehicle. You also never memorialized in the report that you saw any drugs or related objects in the back of your car after showing you to the drug. When Mr. Williams was arrested by its threat, he didn't try to hide anybody. He didn't deflect anybody. He didn't resist anybody. He wasn't using an aggressive manner. He basically turned around. His arm on his back. Got his foot in his foot. again, what was the name of the officer?
There, I think attention again.
Jefferson. Okay. Officer Ivan Jefferson, you remember a conversation between him, Mr. Williams, or Mr. Williams, repeatedly say, "Can I call somebody to my job?"
No, I do not agree.
Do you remember a conversation where that officer said, "Don't worry about it, we'll let you make that call"?
No.
You have anything on that? Have you reviewed by?
Yeah, it's no,
You don't remember that conversation?
I do not.
Okay. Now, the vehicle, as you stated, is in town, correct?
Yes.
Mr. Williams was never allowed to make a phone call with somebody.
It's for policy, so it's in the investigation, but not something.
So, neither yourself or the other officer gave Mr. Williams the ability to get somebody else to pick up was legally part of it.
I transported Mr. Williams, and then he stated that we needed to be on the investigation. So there was no need for a phone call because it was kind of different.
So the answer is no, even with the other officer gave Mr. Williams the opportunity to get somebody else to get that legally part.
There was, we weren't giving you an opportunity because the vehicle was coming from investigation.
So the truck is in the and then you stated, Mr. Williams was arrested for the job, right? And you said he had no life, he had or no death. Correct. So the truck gets to the impound lot. Detective Bidden requested officer Fulton DOTDLL to bring his person.
That's correct.
So no evidence whatsoever of the drugs. No evidence whatsoever of drug-related objects, but drugs in the all comes to this case.
That's, I will say to you, anything to do with that, anything to do with the job is going against.
And before that person you did go into and say, you know what, I have probably called it to this person.
I wasn't going to be ruled out first one. And as I said before, because actually didn't have that time to be investigator, and he's the one who did.
So before that dog, when you dismissed that vehicle, neither yourself or any other officer was like, I can call to get a vehicle search.
As I said, you were going to speak to
To the best of your knowledge, you don't have.
I know that we had probable cause, and we will offer the investigation we had. However, I would see, Detective Gooden, the investigator on that, I was on patrol and very much in morning afternoon, so his decision on that, we will have to ask him what his decision on that is.
And we'll talk about his decision, but I'm asking you, based off of the information you have, we know for a fact that no officer went into that vehicle probable cause for search before the dog.
And so the vehicle came to block, we sat there waiting for everyone to get.
I want to come back a little bit before I do. More likely to be my report that that dog alerted the people on drugs in the vehicle, right?
Yes,
But you know, based off of the investigation, drug and hepatic,
yes, yeah.
you know that based off the investigation, there was a cop in the other time.
Right.
Now, I want to jump back just a little bit, and this may be due to but in your specific type, do you recall the exchange between Officer Yavashenko and Mr. Williams, where the officer said, do you have anybody to come get the vehicle? Mr. Williams' response was, yes, all right. Right after that, Mr. Williams said, hold on, I need to call somebody. You call that? Right after that, speaking to the same officer, Mr. Williams said, I need to call my people real fast so they can come to my truck. You don't call that either? Himself with everybody, and after the officer and the other Mr. Williams had that conversation, you actually said, if you're letting let Mr. Williams get that call. You know, the work officer, the other ship said, they were going to lock the car down for now, go down to the station, and they'll let you make a call break. You know that? Okay.
I know about the car.
But you don't remember any of those documents. If you and also the other ship told us what it is, if you really haven't talked about it.
I don't remember, to be honest, I was trying to command state and I thought to me that.
If you're not saying.
He's saying that he was in my decision.
So, Mr. Williams gets taken down to the police department, officer. And are you aware that Mr. Williams asked Officer Goodman, that he needs to call somebody to pick up his truck because he was told by it was going to be paid?
I do not remember that conversation. I know that at the police station, the one thing I do remember, and the first thing I want to see, they both arrested.
So you don't remember any of the times that all three of the officers told him that he can have somebody to pick up his truck. So Mr. Cole, as you said, came to the police department June 9th, 2022, right? Then Mr. Williams was arrested July 7th, right? Because of the vehicle searched the next week, July 8th. Right? You never memorialized the street language before that you had probable cause to go out to search 980 Pine Grove Road before the police investigation. And you never wrote at the report that you received information from anyone in Roswell PD, or anyone in South Fulton, or anyone in the county, that they had an autonomous call to search 980 Pine Grove Road. Is that correct? And you never memorialized anything with a pre-connected report, which you had a probable cause to search 990 Pine Grove Road before the shooting was arrested.
Okay, so, fully separate, dealing with some government, but still, and not talking about the residents of certain people.
Let's do that. When we get there, Mr. Moon, the nigga I heard was, what's the address? I got 989.
There are two, 980 Pine Grove Road, 990 Pine Grove Road.
What's your response?
You want a response? Is the state literally spent 20 minutes talking about all these different residents, all these different communities that I have. I'm literally narrowing down exactly what she put in her report regarding all of these different positions and vehicles. The states, she spoke about. And literally spoke about it. I was saying, what we talk about. All right, I'll thank you. So my last question, never memorialized in the complete report, she had no probable cause to search 990 Pine Grove Road. Before this movie.
At that time, we weren't getting ready to do it at that point. it happened that Mr. Williams drove down the road on that day. It was an ongoing investigation. I'm sure as you know, police can do this all the time.
So the answer is no. Between June 9th, 2022 and July 7th, 2022, you never memorialized your report indicate that you had a probable cause to go to that evidence before the arrest. The answer is no.
It's an ongoing investigation.
And you never memorialized it in your report that you know the Roswell Police Department or Southwood or Fulton County. So that you had no probable cause to search the 990 Cocktail Road before the school was. You know, well, I think the complete report that we had no probable cause to search the facility before the school was correct.
Yeah, but we have any police reporting to address them.
And so you have to assume before you do it. I'll have that.
Well, I would sustain this education.
That's just so the record is a little clearer, Ms. Delaney had her interview on 9/15/2022. That's how about it.
Yes.
Okay, and Ms. Washington had her interview on 18/7. Sounds about right as well.
Yeah, that's something.
We,
I'm here, you know, we try to do the word impound research. You made reference, I think, in testimony, because another person. But if you explain the difference between impound and securing now, like this person versus seizure.
So just, we use the word impound, which means we are taking someone's vehicle and we are, depending on what that purpose is for, we will kind of. So if we are impounding a vehicle because it's in the roadway, that we have no reason to get a search warrant or anything, we will have the tow truck come. They will pick the vehicle up and it will actually go back to the location in American Deal in Roswell, which is where all of our vehicles go through for impound release. If it is being brought back to the police department due to the fact that there's an investigative hold on it or it's coming to be processed, like the or whatever the parameters are in that regard, it's still an impound. You're still taking the vehicle, but instead of it going somewhere and towing, it is brought to the police department, which is behind the secure fence. So that way we can control the area that is located so that no one is tampering with it or, if we put an evidence base to protect any kind of evidence. So that's where the difference is. So an impound, whether it's just impound for release or an impound for investigative or evidence base.
So in this case, there's an impound release.
It was impound for investigative.
And when a vehicle is being impounded for investigative, is it of any relevance that someone that's doing something?
It doesn't matter. At that point, it's being seized on impound for a warrant to obtain to go into that vehicle. And the reason we wouldn't call someone is because one, the vehicle can move. So at that point, it's an action for circumstance. And so whoever had the expertise for that vehicle, we have no idea about paying about that vehicle. They took that and all that and stop the connect. So no, at that, we do not need to give anyone the ability to call. However, if we were impounding for different reasons, that if the car was essentially to an employee, it could be a release, absolutely, we would get a phone call, to be able to call a family member, or whoever, to come and retrieve that vehicle. And again, it's not like a property, so for it to stay, you would have to have permission for that vehicle to stay there, otherwise it needs to go.
It's fair to say that part of the reason for the seasonal administration preserve it. Someone else included.
Absolutely.
You can make sure someone's breaking the window, things out of it.
Absolutely.
I'm going to go to the question about the police department, the moment we determine that public health. Is it good common practice? Social rates. That each time you hey, now I have public health. What about the report? And I think the witness.
It depends. So every case is different. And so, again, timing also plays a part in it. So if you're working on an investigation and you have to proceed to go, doesn't mean you have to go right then to get this search warrant. Maybe you're trying to do something different. Maybe you're trying to, still get other information before you go. And sometimes things happen, such as Mr. Williams driving down the road on July 7th, he happened to drive by me with active warrants and I arrested him at that point. That was my job as uniform patrol. You have a warrant, and unfortunately, we were in an investigation, and at that point, we did have that, but maybe at that point, Detective Gooden didn't feel that it was necessary up until we got the arrest, that we should go ahead and pass on. Make the settlements.
When we go back to the question about your noting other accidents, did you know that?
Yeah, they were noted, and they're noted at the beginning of the report.
And so they're above, basically above the time.
Absolutely, yes.
If you read the report, page 1, the last sentence, there's the
Absolutely.
You said something interesting right after us. You said one reason why we kind of flood because if someone else about what you said, you said they could have gotten rid of all the evidence. That's what you just said.
Yeah, if there was evidence in that truck, and yeah, it would have been, someone could have gone in and taken it. And even after the fact, there were phone calls between Mr. Williams and his son, Leon, as well as the one talking about, you guys gotta get that stuff off that truck, and that stuff off my truck. And he's always been people to do things for him. Yes, maybe that was after the fact, but at the end of the day, if someone wants to have something in that vehicle, they're going to want to get rid of it. You don't have someone to do that.
So you look at there was evidence in that check.
I would, we call it evidence after because we found that after the fact, we searched them. I said as evidence because let me rephrase and say there were items in a truck that could have been removed that at the time would have been evidence, they could not have been evidence. However, we had to search them and found evidence.
So it would be in this statement, scanning report today, telling the judge there was no evidence in that truck. All the truck we got.
And so we can find.
It would be in this statement, the scanning report today, telling this judge that there was no evidence in that truck that's involved with this investigation.
There was evidence in the truck.
Now, you testified earlier about Mr. Williams at the police department, being technically there, he asked you to go to the truck. You know about it?
To go to the truck, his truck at the
It's already.
yes.
Okay. You remember the exchange between you and the detective Williams, where you said, I guess so, I need to get a search warrant for that car. And then he said, yeah, 100%, need a search warrant in that car. You said, the phone in the house. You remember that?
I don't remember the exact details, but I know we had a conversation talking about it. And as I stated earlier, I was a patrol officer, so I was very much in the face. So me asking that question was looking to someone who had that experience to say, as an investigation was on, maybe all of that.
And after that exchange with the detective Williams, you didn't get a search warrant for the car.
Again, I'm not going to speak for the dog. We can see things that again.
I'm not asking you to speak for the dog, I'm asking you, what happened to the fire? Okay, the search warrant, the truck, the home, and the house. You went to get a dog first.
Yes, and so, as I said to you before, we can have to check the pin on.
Brian, you know,
So, Mr. Williams, sometimes when there are conferences at the bench, this is your case, you have the right to be present for anything and everything that happens at the bench. But you can also waive that right. So, we have a term who we're talking about, this my question is, do you have any objections to us having the bench conferences? If we have a bench conference, we will, if we have a bench conference, we will make sure the after conference will be discussed with you, what was discussed at the conference, so that you will know what happened. Otherwise, we will not have bench conferences. We will do whatever else is necessary to make sure the objections are heard. I guess my first question is, do you have any objection to us having the bench conferences without you being present? And then informing you that you will be what happened. Yes, we have an objection, or yes, we have a bench conference. We have. So, now, Mr. Williams is waived his right to be present during the bench conferences, and I'm trying to prove that you inform Mr. Williams what we just discussed. Yeah. So, Mr. Williams, are you comfortable to understand everything with these proceedings? If at any time you have questions about what's going on, or you think we missed something, please let me know. It's my intention that you understand that you are part of everything that happens in this case. I know it's also Mr. Hoover's, but I've sent the Zoom link to the parties. So Mr. Hoover, really.
Mr. Williams, right now, you go and turn off from the us. There's a point for us.
Yes, sir.
Sorry. I'm trying to figure it out. Continue. Place your truth on the facing. There you go. It is. I know you are. You're unsold. This month. Turn on volume. Can you grab the volume? Okay, well, that Yeah, I'm gonna stop by the station first, okay? You got where your keys at? You have the keys? I haven't. Yes, I know. I'm gonna take. Yeah, you have one out of Roswell. Yeah. There's an actual one out of Roswell. Or that part section. Okay. Yes, sir. Oh, you got that? I need a couple. So,
Now you remember you and all the other officers. And we never gave a single guy. So you never gave it. Now, also, you testified that you communicated with Oh, yes. Leave it right there. Okay. Okay. Yeah. So, this first one for that part. 100%. And then hours. Now, I'm saying that we need certain ones that are the times now. But right after that, we need to just search the development. After that conversation. Between the time we had a conversation, the time all we have to say, they're all this called out. Then during that part of the conversation, we know it, you're very.
We are having a conversation between.
We are very fun. During that conversation, we don't say, we don't have to talk about it. Yeah, still, it's going to be a job. very, very, look, we just saw, there's prior to the new search. You're not putting it on prior to the search. I believe the same one, you see that. I believe the same one, so. So, let's just say, they can say, we should have all the costs.
That is where Mr. Williams asked for this. If he hadn't asked for that message, he may not have gone, we hadn't gone. We would have still gotten a search warrant, this protection. So we were going to get a search warrant no matter what. You're playing off of a conversation that I don't think talking about myself. We did talk first because I don't want to talk.
All right, thank you.
Thank you. Oh, yes, sir.
Step down. Stay, they call this. Say that includes two. All right, let's take 10, let's take a 10-day first break and we'll come back down.
What you need your bag? That's a nice bag. Now we have time to test it. That's right. Okay. Yep.
Yeah, and we'll use it in separate. Sure, but I have a time, so here's the thing, technically I'm not in contract, yeah, but I need to be working in the garage. But yeah, you know what, I'm scheduled. So I'm going to some. Okay. Yeah, it takes a couple hours and then emails. All of them, have an email, stuff, and I really took myself yeah, and then
You want the candy bar? Your boss is here. We'll make sure you got that.
You should take it.
Already.
Take it and give it to me.
Okay, perfect. Thanks.
Can y'all hear me? I don't know if y'all can hear me, but I've been quiet all this time because court was in session. But anyway.
What on the order?
Okay. Yes. Oh yeah, it's not recording, but I'll turn it down. Yeah, I've been having difficulties with this camera, I'm telling you.
Let's get everyone on the record. Hey, if you would put your full name on the record for the
Yes.
Lauren Stewart, LOU-STEWART.
Very well. So evidence in this hearing is closed. State has an heard now with the state first and last, or state's hold on.
There's always a reserve.
Okay. All right, Mr. Hoover, turn it on.
I'm sure
Williams was the driver of this vehicle, so he does have the standing. Under Georgia case law, I won't go into all of the cases, but I will quote them for the record. The first is State v. Carter, 299 Georgia Ave 3, 2009 case. Mobley v. State, M-O-B-L-E-Y. V. State, that's 307 Georgia 59, 2019 case. In that case, quotes Carpenter in the United States, 138 SCT 2206 of 2018 case, as well as Katz v. United States, KATZ v. United States 389, US 347, 1967 case. But finally, United States v. Jones 565, US 400, 2012 case. So it's clear that Mr. Williams, as being the driver of that vehicle, has worked in the standing, especially when it comes to this motion to suppress. Now, Your Honor, in the state of Georgia, we have exclusionary rule. The primary reason for the exclusionary rule is to deter misconduct, whether it be negligent or intentional. And that comes from State v. New NEW 331 Georgia Act 139 2005 case. When evidence is obtained in violation of the Fourth Amendment, the judicially developed exclusionary rule usually precludes the issues in a criminal proceeding against the victim of illegal search and seizure. The purpose of the exclusionary rule is to deter unlawful police conduct and thereby effectuate the guarantees of the Fourth Amendment against unreasonable searches and seizures. Now, since Mr. Williams has a Fourth Amendment, has Fourth Amendment standing here, Your Honor, there are a couple of exceptions to the Fourth Amendment that I'll speak about because the state has the burden to prove to you that one of these, or A, that the search is legal, or B, that one of the exceptions applies. So the first one is the automobile exception. There's been no testimony regarding any automobile exception also does not apply here. The second is an exigent circumstances exception. In their response to my motion, they didn't say anything about exigent circumstances. However, this witness did say she used the word exigent. I don't believe she actually said what the exigent circumstance was. So I don't believe there's any testimony whatsoever that it applies in this particular case for this particular search. There is no, in Georgia now, there is no state statute governing procedure exception. We used to have that, but here in the state, GARY, the state 252 Georgia 573, a 1992 case, says that that's no longer good law here in Georgia. And under Georgia as well, exception, with the state 343 Georgia Act 774, 2017 case, David Jerry v. State, that I just quoted, and OCGA 17530 on both of the state. There is a good exception to the Fourth Amendment in Georgia moving forward. Now, I do want to get into the ethical discovery doctrine exception. That's something that the state could do. Again, there's been no, I believe that's where they're going to use most of their arguments on it, the ethical discovery doctrine and independent source doctrine. So the first case I would like to quote is Davis v. State. That's 262 Georgia 578, 1992 case. We cannot allow the exception to the exclusionary rules to intervene in this, the award requirements of the agreement. Inevitable discovery involves no speculative elements that focuses on demonstrated historical facts capable of ready verification and teaching. I believe this case is really good for Mr. Williams' argument because the state's going to get up there and say because they're working in ongoing investigations or we were looking into something else or other law enforcement agencies were looking into something else and somehow they fall under the inevitable discovery doctrine. However, there's been no testimony. I'm going to get into more. There's been no testimony based off the only evidence the state presented. All we have is an ongoing investigation. That's not enough to get. It's not enough to allow the state to violate the conditions for the. That's not enough by itself to get somebody into your house, to get somebody into vehicle to get somebody on the person, to get somebody to go into any type of personal electronics that you have. There needs to be more than, well, investigation will happen. No, Your Honor, and I'm going to get into the timeline a little more as we go. At no point before Mr. Williams was arrested did they have, or what they believe, probable cause to go into those homes and to go to electronics, or to touch any of the vehicles. So the state has not presented any evidence of being able to discover by perception. There's also a Mobley v. State, 307 Georgia 59, 2019 case. This court has explained that for a never discovery exception to apply, there must be a reasonable probability that the evidence in question would have been discovered by lawful means, and the prosecution must demonstrate that the lawful means which made discovery inevitable were possessed by the police and were being actively pursued prior to the occurrence of the crime. Again, I'm not going to get into the evidence that was found in the vehicle because now we do know testimony that there was actual evidence in that truck. I'm going to get into that evidence to further point out how they couldn't get to anything else until I got the materials and the electronics and the evidence that they found in the truck. Molly also says the mere fact that the investigator obtained a warrant on the following day is nothing. So again, there was a lot of testimony. Well, we could have done it, but that's not going to be wrong. The state has to show more than just we could have done it. So that takes me to the independent source document exception. The first case I'd like to quote is Tatum v. State. That's 319 Georgia 187, a 2024 case. This court is quoting the rule from Murray, MURRAY. If the second lawful search was not prompted by the prior unlawful search, then the independent source document applies. And the state is in the same position it would have been if the unlawful conduct had not occurred. But if the second search was prompted by the original unlawful search, the evidence must be excluded so that the state does not benefit from its unlawful conduct. Under such circumstances, the independent source document should not and cannot apply. The second search is without color, the second, third, and the fifth deals with the residences, deals with the storage unit, deals with the vehicle, deals with the electronics. All of that happened because of the first search. This is a legal search of the truck. The state has presented no evidence whatsoever that the officers, any of the law enforcement agencies we talked about, ever had a probable cause to do that. It's actually the opposite. They were still in a pending investigation. And then the officer tried to say that they had, they were going to do it. There's no evidence of that at all. The only evidence is active investigation, and all of a sudden, this one being happened. Oh, now we can get into it. The officer literally said on the bike, we needed a search warrant to get into that vehicle, to get into those houses, and the phones and the computers. She literally said the words. She tried to act like she remembered saying it. Thankfully, her body can't was functioning properly that day. She literally said, she could say, we had the probable cause. She could say South Fulton, Roswell, Henry County, or anyone else has the probable cause. What she said was, we need to get a search warrant for all this. How can we do it? The evidence also shows, Your Honor, that after she made that comment and her and Detective Goodman were talking, they didn't just go and get a search warrant. They got a dog, or they requested an officer to bring the canine. That canine sniffed the vehicle and allegedly alerted to something. No drugs were found, no drug related objects were found, no evidence whatsoever there was ever drugs or drug related objects. So now, that's when they did the search. It wasn't before, it was after. It was an illegal search from the very beginning. I would like to also quote Ken Brew State. I think I'm saying that right. KENNEBREW State, 304 Georgia 46, 2018 case. The state bears the burden to show evidence sufficient to establish the predicates for the application of any exception. So all of those exceptions, Your Honor, that I brought up just for the court to know, the state bears the burden to say, Your Honor, this is the exception, this is how we prove it, this is why we move forward. And with the other statements, I don't think it's going to make that all. Now, I'll make sure I don't listen. So the arrest warrant, I think it's pretty clear now, but I just want to make sure it's extremely clear on the record. So the arrest warrant EW 0328723, which is the death by deception out of Roswell. I was never fighting that. I was never trying to suppress that warrant. What I was doing, Your Honor, again, was I had to address that warrant because that led to the arrest, that led to the search, that led to the collection of evidence, that led to other searches and other collection of evidence. So just to make sure it's clear on the record, I'm not suppressing that one. So the facts are clear, Your Honor. On July 7th, on June 9th, 2022, that's when Mr. Pearl, K-R-U-L-L, went to the police department to talk about basically not paying rent. Between June 9, 2022 and July 7, 2022, again, no law enforcement agency ever went to get a warrant for any judge to go into any of these properties. Then one day, this patrol officer who was doing surveillance drove past Mr. Williams in the white F-350. Now, it's important to note, Your Honor, that Mr. Williams didn't make any traffic violations. Mr. Williams, the vehicle itself, there wasn't a photo out because it was involved in any crimes or anything like that. The vehicle itself ran functioned properly, drove properly, and there were no traffic violations at all. That's extremely important. By the time they got to Mr. Williams, that vehicle was already legally safely parked in a private parking lot. There was no obstruction in the roads. There was no obstruction in the parking lot. The manager or the person that owned the lot didn't say get it moved. The person that owned the building didn't say get it out of here. There was one furthermore, on it. When they arrested Mr. Williams, he had already got out of the car, took the keys, closed and locked the door, and he was, from what I could see, over 50 yards away from the vehicle. So at this point, this vehicle, there's nothing illegal about the vehicle. The warrant that they arrested Mr. Williams on had nothing to do with the vehicle. At the point where they arrested him, half a football field almost away from the vehicle, that tells you that the vehicle could have stayed right where it was. It was safely, legitimately where it was. Thankfully, we had a body cam that works because officer, I'm going to just spell the name, YABTUSHENKO, told Mr. Williams that we will let you make a phone call so a legal driver can come pick up your illegally parked vehicle. Said that multiple times. Officer Fields also told Mr. Williams that they would definitely let him make that phone call multiple times, and they never did, Your Honor. That's extremely important because, again, the vehicle itself was safely parked in the interrogation room. Again, Officer Fields wants to come to shoot and remember, but even Detective Gooden tells Mr. Williams, yes, we'll let you make a phone call, just hold on a second. Now, at that point, they had already made the decision to impound this legally parked vehicle and bring it to the police department. They were never going to let Mr. Williams make a phone call. They were never going to let a legal driver with no issues, no warrants, and a valid driver's license come pick it up. They weren't going to make the call for them. They weren't going to see how long it would take. They had made the decision as soon as they arrested Mr. Williams to impound this vehicle. They lied to the entire time. So now I want to focus on Georgia case law when it comes to impounding the vehicle. The first case is State v. Lowe, LOWE. That's 224 Georgia Ave 2228, a 1997 case, and Scott v. State, 316 Georgia Ave 341, a 2012 case. So in Georgia, case law related to the impoundment of legally parked vehicles generally stems from Fourth Amendment jurisprudence, which prohibits unreasonable searches and seizures. If a vehicle is legally parked and not causing any obstruction, public safety hazard, or violation of law, impounding that vehicle could be a challenge as an unlawful seizure. A legally parked vehicle cannot be impounded without justification, such as being a danger or obstruction. While officers cannot impound the car merely as a pretext to search for contraband, they may impound the car if they must take charge of it for some legitimate reason. At this point, Your Honor, there was no legitimate reason. They never said they smelled drugs. They never said they saw something that looked like drugs. They never said that they saw something that looked like it could be illegal drug-related objects or items that could be reminiscent of some type of crime. There's no testimony at all based off of any of the officers that were on the scene or the one officer that took the stand that said there was any legitimate reason for them to impound a legally parked car.
They have those two sites again.
Yes, Your Honor. State v. Lowe, LOWE, 224 Georgia Ave, 228, 1997. And Scott, SDOTT v. State, 316 Georgia Ave, 341, 2012. And there were a ton of cases on this, I just think 2,700. Now, Your Honor, again, after they already made the decision to impound the vehicle, after they already violated Mr. Williams' right to basically at least attempt to get somebody to come get the vehicle, then they take it to the impound, and we know they are literally still conspiring to get into that vehicle. How can we get into this vehicle? How can we get into these houses? How can we get to these electronics? They didn't say that we had enough. They're still trying to figure out how. And on the lower behold, they call the drug dog. The drug dog comes out to the truck again. Here's the problem with that. Now, the drug dog alerts, hey, now we have probable cause. Let's get to that truck. Now you can find the truck, it's fair game. That is not how this is supposed to work. They're not supposed to count any kind of vehicle in the first place, and they're never supposed to search the vehicle. Now, in the vehicle, Your Honor, there were a number of items, and I'm going to break down the warrants as best I can. So there were a number of items found in the truck once they legally searched. Yes.
This is on the return.
All right. So the search warrant for the Ford F2, for the Ford truck, SW030244. They get into that truck and they find a black book bag with multiple documents. First document goes to 2155 Bent Creek Manor. That was a Wells Fargo letter that was dated April 15, 2022. That's when what officer just said, that's the first time she heard of it. She realized there was another residence that came from the black book bag. Second, there was a receipt for Precinct 1 autos, and that goes directly to count 26 in the indictment.
So these are the documents.
Yes, it's on. And that goes directly to count 26 of the indictment. Also in the book bag, there was paper with Melody Stretch's credit card number on it. That goes to count 26 to 30. Melody Stretch is no victim in this case. And again, there was no testimony they knew about her before, and now they have these credit card numbers, and now they have warrants for it, which turned into charges. There's also a check from William Ford for $2,852 that was also found in the book bag. That connected them to Gail Big, who this is another alleged victim in the case, Your Honor, which also is tied to not only some of the acts in count one, but multiple charges in the indictment as well. They also found an invoice for a G-Wagon, or for a sale of G-Wagon, that gets tied to other charges, that gets tied to other alleged victims, that there was no testimony they had beforehand. There were multiple hotel invoices, that gets tied to an alleged victim. I can't say his name, so I'll just spell it. THWAITES. Again, their testimony, they knew about that, they were an alleged victim beforehand. They also found notice for payment for Palmer Dodge, dated December 22nd, 2021. Again, that goes to counts 24 and 25. It also goes to warrants EW037-1530, and also a warrant EW037-1529. They also find in the book bag silver and black, spell it GETAC computer. That goes to case number 2210-001198. There are 3 warrants signed by Judge Woodford, signed by Judge Witherspoon, Judge Lodge, and Judge Ford. First warrant number is SW030520. Second number is SW031091. Finally, SW032563. All of that was found in the book bag as well. Also found in the book bag 3 iPhones. Because the phones that you hear Officer Fields talking about, we need to get a search warrant to get them as well. There was a black iPhone, or 2 black iPhones, 1 gold iPhone. For those devices, search warrant 030-519-031-090. Let's see, the gold iPhone specifically, Your Honor, gets them to Mr. Williams' iCloud account and his Instagram account. Also gets text messages between Mr. Williams and other people related to this case. Also gets photos of Mr. Williams and other people related to this case. None of what they had before they illegally searched that vehicle. Also found in the book bag was a scanned disk 32 gigabyte USB drive. Search warrant 030520. Multiple keys that were found in the vehicle. Search warrant SW031938. And not only does the majority of the stuff just found in a book bag go towards another case, it goes towards predicate acts in the count one, the RICO count, which is the murder that we filed our brief on. They also go to specific charges in the actual indictment. Mr. Williams wants you to believe that nothing in that truck is going to be used in this case. That officer testified in a different way. It's clear looking at what the testimony from the officer was before the arrest and what we see come out of the arrest and out of the illegal search, which led to other searches. They're literally indicted charges on this case. And Mr. Williams wants to tell you that none of the arrests legally found applies to this case. That tangential argument is completely wrong. It's fundamentally wrong. So again, Mr. Williams has Fourth Amendment standing. This is not a search incident to arrest. This wasn't an inventory search. There was nothing that was found in plain view. There was no probable cause whatsoever to get to that vehicle or anything else until these officers conspired, lied, and created the probable cause. And as of right now, not through witness testimony and not through the response at the state giving you any Fourth Amendment exception that will apply in this case. Now let's focus on subsequent warrants issued based off of the search warrant. Again, after they got into the truck illegally. And let me back up. So it was kind of confusing about how she got information at what time, because she literally nitpicked what she was trying to say. So to make it clear, Your Honor, just to give you an idea, Miss Delaney, Delaney, who was part of this indictment as one of the alleged victims, she didn't give her interview until 9/15/2022. That's after Mr. Williams was arrested. Ms. Washington, also part of the Harley-Davidson and other charges in the case, indicted charges in the case, she didn't give her interview until 8/27/2022, after Mr. Williams was arrested. All of this information came because they got into that truck illegally. They found other stuff like, oh, this points to a house. Oh, this points to another vehicle. Oh, this points to another resident. That's how they got there. So to make it clear, they were having ongoing investigations, but they never had enough to get that person into a search warrant until after. So we're talking about search warrants for 980 and 990 Time Road and Westwood Road, 30075. They were all searched after Mr. Williams was arrested, and after they impounded the truck, and after they searched it. So warrant SW030257, signed July 8, 2022, when they searched the truck, 990 Pine Road. In that search warrant, Your Honor, the officer seized 10 cell phones, one belonging to James Rutherford, 3 belonging to Eric King, 1 Samsung phone found in the master bathroom, one plus phone found in the master bathroom, 3 TCL phones found in the master bathroom, 1 Rose Gold iPhone found in the closet. They also found 1 silver iPad, 1 MacBook Air laptop, 1 Apple desktop, 1 HP desktop, 1 Campbell bag. In that Campbell bag, there were 3 licenses, 3 credit cards, and a checkbook. They found 1 Pinky wallet with multiple credit cards in it. They found 2 to 5 legal stamps. They found the Rolls Royce Ghost 2011. They found a silver Cadillac Escalade. They found 2 keys, one to a Honda, one to a Rolls Royce. They found a box of fake money, They found 4 notebooks with information in it. They found a Georgia driver's license for Tammy Strong. They found a copy of the Georgia Secretary of State professional license report for Tammy Strong. They found an IRS notification of an employer education number, EIN, for the National Claims Service LLC. They found another EIN for portfolio of receivable partners, none of which you heard testimony that they knew about before they searched the vehicle and got to the house. Search warrant 030256 980 Pine Road. I conceived a 2014 Black Bentley registered to Mr. Williams. 2020 Harley Davidson. At this point, there was an ongoing investigation, but there was no evidence that if we ever go to trial on this, you'll see, Your Honor, this was a civil issue. There was no evidence that they could come and take that motorcycle, they could come and impound the motorcycle, they could come and search that. There's no evidence that they got the public knowledge at the time they searched for it, and they didn't. The evidence shows that they actually did. That goes to count 15. We also found a 2021 blue Harley Davidson, FLTRX.
Your Honor, I have to. The word very clearly a Harley Davidson was on the truck. According to the truck first, and if necessary, getting these other things, that's when you hear evidence about the other things. So this is again far outside of scope.
So let me do this. I'm gonna hear from Mr. Cooper. But the information I think I need right now is, because what I'm writing down is search warrant of the residence at 980? Yes, that's the second. And then anything from that. Yes, I'm sorry. I got you. I don't need the full list of things that you believe are out. I just need the search warrant that you believe, or evidence you believe is somehow connected. I don't need the whole list.
Gosh, I'll just give you the search one. Yeah. So that 980 search one is SW056. I think that's the last one. Yes, well, I'm going to.
Your contention is everything from that search warrant.
Yes. Now, I also would like to touch on the state's response briefly. So in the state's response, and when the state first spoke this morning, they basically said they opposed the motion on the grounds that it's not right for adjudication, and that those such efforts will be used by them in this trial, in fact, number 24 SC 001723, which I believe is inherently untrue. The cases they use, Your Honor, to I guess explain that this stuff is just tangentially related to the actual case. I do have to talk about them. So to prove that it's not right, my motion is not right, the first quote, United States v. Plummer, PLUMMER. In Plummer, Your Honor, the motion to suppress statements is physical evidence references a 9mm pistol that was seized from a car driven by the defendant when he was arrested pursuant to an act of warrant. Additionally, they went to the defendant's girlfriend's house and found drugs there. However, the girlfriend wasn't connected and he wasn't arrested at the girlfriend's house, he was arrested in the car. And basically, the argument at first was the evidence of the drugs shouldn't come in because it had nothing to do with it. However, Your Honor, in regards to the rightness issue in Plummer, the parties were in agreement that any issues regarding the seizure of these items were not right for adjudication. So the first case the state wants to tell or wants to put in your direction about it not being right literally says the state and the defense got together and agreed, okay, it's not right now. Let's talk about it later. That is not happening here. I'm not sure why they put in that case, but I just want to let the judge of the court know that case has nothing to do with the issue we're talking about today. The second one, I'm going to spell it EIONNE B. Ross. Again, it's a case that the state used to show that my motion is right. In this case, Your Honor, if regarding plaintiff's prayer for suppression of any material which might be obtained or sought by the IRS in the future. This case was a man who was trying to stop the IRS using a tax code, 26 USD section 7421A. He literally tried to stop the IRS from investigating him under a tax code. And what the court said was, it's the IRS, they can investigate pretty much anyone they want. It's not right, but you can't prevent them from doing their job. It has nothing to do with what we're talking about here, Your Honor. We're not talking about a Fourth Amendment issue. They're not talking about a Fourth Amendment issue. They're not talking about an illegal search. It has nothing to do with what the state claims to do. I want to bring that to the court's attention. And the last one, West v. Saginaw TWP Police Department. And they're saying this case shows you that everything I'm trying to keep out is just tangential. In this case, Your Honor, well, first, it's a civil case. It's not even a criminal case. But so the plaintiff claims that his arrest, well, let me back up. Basically, in that case, the plaintiff tried to civilly sue the officers that arrested him in his criminal case. The court says that it appears to have no, his motion appears to have no relation to this matter. It is not clear, however, whether the plaintiff is seeking suppression of such evidence in this matter, the civil case, or is he arguing that the evidence should have been suppressed in his criminal trial? When you trial criminally, laws apply this civilly, and the court doesn't even know what type of motion he's arguing, who is aimed or which case it's aimed at, and what's happening. So the court says, thus, plaintiff's motion appears to have no relation to this matter. Again, that has nothing to do with what we're talking about today. It has nothing to do with Fourth Amendment protections. It has nothing to do with Mr. Williams' constitutional right to not, for the officers just not to go in and search him because, quote, we know who we are. So for those reasons, all the cases that they quoted have nothing to do with what we're doing right now, Your Honor. They have not given you an exception to the Fourth Amendment rule. Georgia case law is clear. They had no legal reason, no legitimate reason to impound that vehicle. And they get up and talk about what we had an ongoing investigation. The testimony showed you they didn't get any of the search warrants because they couldn't until these officers conspired, lied, and came up with a way to get into that vehicle. For those reasons, we ask that you allow us to move forward to show you exactly all the evidence.
So before you have a seat, and I know you said it twice, and I have attempted both times to write it down. Right, no, but you're gonna have to slowly tell me what search warrant or what warrant number and what evidence that warrant number relates to, that you believe the police were only able to get because of items found in the truck.
Yes,
I have the residence at 990 Pine. I have the residence at 980 Pine Grove.
okay. So, yes, okay. So specifically pertaining to charges 24 through 25 and some of the credit attacks, warrant EW 037 1530, warrant EW 037 1529.
Those are arrest warrants.
No, these are warrants for fraud efforts, but it stemmed off of a home garage payment notice that happened to one of the residents.
But are they warrants to seize the property or warrants to arrest, or were they warrants?
I believe they turned into warrants for it. The next warrants is for the computer that's found. SW, these are certain warrants, SW 030520.
That's the 030.
030 520 SW 031 091 and SW 032 563. Let's go back. I believe that the first two I just spoke were for arrest warrants because all of the search warrants talk about that stuff.
Right, that's not about EW warrants.
All right, so the next one,
So those search warrants that you just gave, those are for computers?
yes, computers that were found inside the vehicle.
All right, so going back to, there was a black and silver G-Tech computer.
Yes,
Okay, so those warrants were gotten to get inside of, open the computer and see what's in it.
3 objects.
Give me a second.
And to be clear, that particular piece of evidence and those 3 warrants go to case number 2210 that 001198. Next. Now, these are for the icons that we found in the vehicle. Search warrant 030-519 and search warrant 031-090. Okay. So for the USB drive that's found in the vehicle, search warrant 030-520. That's for USB. Yes. The multiple keys that were found in the vehicle. Search warrant 031-938. And I believe they are tied to arrest warrant 040-8973. Arrest warrant 040. Let me back up. Arrest warrant 220-040-8973. It's those directly tied to theft by deception charges that were ultimately indicted, or charges in this case, I believe, were accident. So we got the one for 985 road, yeah, for 900. I believe that's all of them, Your Honor. And if we get to the point where I can delve into what happened with those warrants, then it'll further explain why I mentioned.
And let me recap what I wrote down. All right, so, you believe that the search of 990 Pine Grove Drive, or anything that was found, that all needs to be excluded. The search of 980 Pine Grove, everything that was found should be excluded. The laptop itself should be excluded, and anything found on the laptop and recovered from the laptop based on these 3 search warrants. There were 2 iPhones or 1 iPhone? Okay.
There were 3 from the vehicle.
3 from the vehicle, but in a search of 2 of them that you believe should be excluded.
Yes.
The search of anything found on the USB drive, and then the one I guess is kind of the keys, I guess. The keys and then the arrest warrants, but I understand there's a search warrant based on the keys, and then they got arrest warrants based on that search.
Without going into more detail.
Okay, all right. All right, good. Thank you. All right, yes, Deputy 88.
Got a lot to cover. Where I want to begin is, I do want to take exception to some of the argument that seemed to indicate that misrepresentation to the court. I've always said I don't believe that this evidence would come at trial. I don't believe that we have this evidence. I believe we turn over this evidence. I stand by that. I've asked Mr. Hoover time and time again to tell me exactly what evidence you're talking about. I've either been told I don't know or I've got no response. And clearly today there's a list that was read in open court and was printed and prepared for today. And if I say that, then you could resolve some of these issues and not take over. So I just want to make sure that the record reflects that. I don't believe that I've made any misrepresentations to the court, and I take exception to intimation that I have.
And I've never, now that I deal with civil, I never take what one lawyer says about another lawyer to be malicious. I always believe the lawyers are honest and can with the court until they show otherwise. So Mr. Williams, I do not believe that you have been dishonest with the court.
Judge. Other thing before I really dive in is, one, just reserve our objection to getting into all these other search warrants. Reportedly sitting from the search for the vehicle, as I stated on the record earlier, the court has kind of given us guardrails and said we're not going to get into that. That's the reason why we didn't put up any evidence for any of those other search warrants. So we're going to talk about the search for the car. So I want to make sure that I reserve that in the record. If we're going to go further than this truck, so you give the opportunity to present evidence on the other things that the defendant claims that are issues with. And to that point, I'd also requested the court instruct the defense to file something in writing. I think we're entitled to have written notice of motion to suppress. So I think that's for another day. I just want to reserve all those things. And then the final thing on that thing is, I know there was some mention about either some computers or other items that belong to Eric King. I know for sure that I did turn over in discovery a hard drive, copy of a hard drive that belonged to Eric King. I don't believe that this defendant has any standing whatsoever to challenge the search that belongs to Eric King. So I will note that also. Turning to the merits of the motion that's on the table today, truck. I think it's important, Judge, to differentiate between an impound of a vehicle for release and a subsequent inventory of that vehicle pursuant to an impound versus a seizure for the purpose of getting a lot of the cases that we heard about from the defense, the Lowe case, the Scott case, and there are many cases on this impound issue. Those all deal with a pure impound. Vehicles in the roadway, vehicles blocking traffic. All of those cases deal with a situation where there's no probable cause to believe that there's evidence of crime. So I don't think that they have anything to do with what we're here to talk about today. I know, and I tried to make this distinction with Detective Fields on the stand. I know that the term impound has been used very loosely, both in the reports and the warrants and frankly in testimony. But I tried to make that distinction between an impound, what was described as an impound for release versus, as the detective testified, under that circumstance, somebody can call and somebody to come pick up the car before it's impounded. That's not what happened here. This was the second category, which is a seizure of a vehicle for the purpose of obtaining a search warrant, and that's exactly. So I want to make sure that that's clear because I think that frames everything that I'm about to say. And so with that in mind, actually, let me make one more reservation for the record. I also want to reserve the issues of the discovery and source, again, on the same grounds that today I think we just filed out the truck. We didn't put out any evidence for the discovery. So that said, moving into the merits of the seizure itself. I want to the court's attention to a case. There's actually a fresh out copy of that case.
Yes.
This case is Reyes, R-E-Y-E-S,
Castro, CASPRO versus the state. Georgia Court of Appeals decision from 2019, the site is 352, Georgia App 48. And the pin site, I'm turning to on page 57, citation, I believe the top of the page is going to this page 13, and I highlighted the portion. And this is a case that talks about what I made reference to, which is the seizure of a container for the purpose of temporary limited seizure of a container for the purposes of obtaining a search warrant to then subsequently search that container. And so I'm going to, before I dive into the case, I want to make a couple of distinctions. This case is about a cell phone. And the case that we're dealing with, this Williams case, is about a vehicle. And so there's no automobile exception that applies to a cell phone. So I want to just point out from the outset, I'm going to talk about the automobile exception a little bit. Looking at page 57 of Ernest Castro, the Court of Appeals noted that for law enforcement authorities have probable cause to believe that a container holds contraband or evidence of a crime, but have not secured a search warrant, the court, meaning the Supreme Court, United States Supreme Court, quote, the court has interpreted the Fourth Amendment to permit seizure of the property and the issuance of a warrant to examine its contents if the exigencies of the circumstances demanded or some other recognized exception to the search warrant is present. Such exigencies could include the need to prevent the imminent destruction of evidence in individual cases. And then the case goes on to talk about the facts of the Ernest Castro case. And then I want to move over one column. I'm looking at the top of the page, so page 16, but I think in the citation purposes, I'm on page 58. But the court kind of sets out a test that determines when a container can be seized temporarily for purposes of abuse. The court held that the first factor is whether a detective or the state has probable cause to believe that the container contains evidence. The court heard through Detective Fields that at the time this vehicle was seized, Mr. Williams had been under investigation for a month. Detective Fields was aware of at least 5, I believe she said 5 open theft or fraud related warrants, arrest warrants for his arrest. She had investigated him based on statements made by Mark Kroll. To correct the record, it's KROL, is a spelling there. And as Detective Fields testified, before she even encountered Mr. Williams on July 7, 2022, she was surveilling him. She was watching the cars that were coming in and out of the Pine Grove residence. She already knew that he was committing identity fraud with Erica King. He had impersonated several individuals, including Nicole Norman, who's a defense attorney right here in Atlanta. May have been in this courtroom before Your Honor. The detective knew that Erica King and Mr. Williams had stolen the identity of a real estate agent as part of the transactions leading up to the renting of the Pine Grove residence. She knew that he had committed bad checks. So it was kind of framed by the other side of what is the right. There's a full-blown criminal investigation going on beginning in early June. That includes surveillance, includes talking to witnesses, includes observing the defendant coming here and there to and fro. She had the opportunity to figure out all of these vehicles that were part of the Pine Grove residence. She knew that one of the vehicles had been reported stolen, and there was an active case in Sandy Springs regarding a stolen motorcycle at the residence. But she admitted that she didn't interview the owner of that until after the fact. But she certainly knew that there was a report of the vehicle stolen. She knew that the defendant had warrants out for stealing trailers. I believe that she said out of Henry County and out of Marietta. Those were active warrants. She saw trailers at the location. She testified that she knew that he had theft warrants out of California. So it's not like Mr. Williams was just encountered on July 7th and everything began there. It certainly did not. There was multiple active investigations going on. There was absolutely probable cause to believe that there was evidence of a crime in that vehicle. Detective Fields testified that she subjectively believed that, and then she explained to Your Honor what supported her subjective belief that there was probable cause to believe there's evidence in that vehicle. She saw Mr. Williams driving the vehicle that day. She noted that the types of crime that she was investigating before at the time involved documents. I believe she talked about computers and cell phones, and knowing that there's a likelihood that there's tangible evidence that he would have on this person. She testified that when she stopped him and pulled him over, she could see in plain view within the vehicle suitcases and backpacks and other containers that are consistent with her understanding that he's going to potentially be carrying evidence of his crime with him. So she didn't just come upon him out of the blue. I mean, this is after a month of investigations, surveillance, talking to witnesses, all these things. And I think it's pretty clear that there was probable cause. She believed there was probable cause. And there was indeed objectively probable cause to believe that there was evidence of certain crimes inside the vehicle. That's factor number one. Factor number two is that the detective has a reasonable basis to be concerned that unless the container is seized, that someone might be able to destroy or tamper the evidence held within the container. She testified that if she had left that vehicle there, that she didn't know where the other set of keys were. She didn't know if somebody could have broken in the window and tampered with the evidence within the car. She needed to maintain chain of custody over the vehicle, so when we got to this point, she would say, we know that nobody tampered with the vehicle prior to our ability to search it. And again, she acknowledged this was after the fact. Her suspicion was corroborated when after the fact, she listened to jail phone calls where the defendant instructed people to go get the car, go get the truck, so that the police couldn't search it. So I think we've established number two, there's certainly a reasonable basis to be concerned about maintaining the integrity of that evidence within the vehicle. Third, the detective made reasonable efforts to reconcile law enforcement needs with the demands of the defendant's personal property. And the example that the court gives there is that in the Reyes case, that the defendant or the detective neither searched the container or arrested the defendant for the contents of the container prior to obtaining a search warrant. That's exactly the case here. That vehicle was not searched prior to the search warrant being obtained. There was one entry into the vehicle. Well, there was two entries. There was, I guess, a body cam seat of the vehicle before it was locked up in the parking lot in front of Domino's. And then there was an entry into the vehicle at the defendant's own request. He said, hey, can you go get my medicine? And so I don't classify those as searches. There was no full-blown search until after the search warrant was obtained. Number four, and this is the final factor, the detective seized the container for a time period that was no longer reasonably necessary for the detective acting with diligence to obtain a warrant and institute a search. We heard the detective testify that it was about 24 hours between the time that the car was seized and the search warrant was obtained and the car was searched. I submit to the court that that's absolutely a reasonable amount of time, given all that was going on. They had to get him down to Rice Street. They spoke to him several times in the interview room. They had to compile all their information. The search warrant was very quickly sought, obtained, and executed. So I think that the Reyes Captain case kind of closes the issue here. And I know that there was some confusion about, is this an impound? Impound for really gives the defendant the opportunity to have someone come pick up the car. That's not what this was. This was a seizure for the purpose of getting a search warrant to search the car. Now, I said I would come back to the automobile exception. The reason I come back to that is Mr. Hoover said that we didn't put up any evidence of the automobile exception. Well, the evidence that the automobile exception applies is that what we search is an automobile and that it has the ability to move. The evidence was Detective saw Mr. Williams driving the vehicle. That gets us there. And so when you take into account all of the prior investigation that had taken place, and the fact that the container that it's shelved is a vehicle, I submit to the court that Detective Fields had the authority to search the vehicle right then and there based on just automobile exception, probable cause, get in the vehicle and search it. But she didn't do that. She wanted to make very sure that her T's were crossed, I's were dotted. So she took the extra step of getting a warrant, that's something that she didn't even have to get,
But she got the warrant to make sure that the search was good, and it was good. I also want to differentiate, and this is in the context of Reyes Castro. I want to talk about exigent circumstances and exigence. I think it's very important to distinguish between exigency for a search and exigency for a seizure. And I think Reyes Castro talks about that because were there exigent circumstances to search that vehicle without a warrant, setting aside the fact that it was a vehicle? I don't think there were exigent circumstances for a search. Were there exigent because you could go get a warrant, right? And that's what they did. Were there exigent circumstances for a seizure? Absolutely. They couldn't get a warrant instantaneously to seize the car and put it away somewhere safe. So they seized it, put it away somewhere safe, and then got the warrant. So I think it's important to make that distinction because we've thrown out this idea of exigent circumstances, and we typically, as lawyers, think of it in terms of a search. But there's a different approach when it comes to the seizure that precedes the search. And so I think that there's absolutely exigent circumstances based on the testimony concerned about destruction of evidence in the vehicle. Again, just coming back to it was impounded. I use that term loosely, specifically for the purpose of obtaining a search warrant. A search warrant was obtained and it was executed. Also, want to, those arguments are compelling. I want to take a look at the search warrant itself because we haven't gotten into this area of the law yet. But let's assume that the challenge is to the search warrant itself. I didn't hear the search warrant itself being challenged. All I heard was that the seizure of the vehicle was challenged. But let's assume that the search warrant itself is challenged. Well, what do we do if there's a problematic search warrant? We excise out the part that's problematic and we determine whether or not there's still probable cause to issue a warrant. And so if you look at the search warrant, and I'm on the last page of the affidavit. Well, I think actually that's what I think we get halfway through paragraph 18. Paragraph 18, the first half of it is prior to the impound of the vehicle. And I think that's important because paragraph 18, beginning of it, talks about seeing the defendant in that vehicle. It's the same her testimony, same vehicle that she knew he was driving based on it coming and going from the Pine Grove residence. So I think as kind of a backup argument, if you look at the search warrant and you, let's just for argument's sake, say we excise everything that's halfway through paragraph 18 down, we still have probable cause to get in that car. It's a low standard as the court does. I would submit to the court that if this detective had brought top half of 18 up to your honor, that she likely would have signed the search warrant for the vehicle. So I think all of these things answer the question. Number one, Reyes Castro answers the question in the sense that it's not an impound for the purpose of, put it in the tow yard and let somebody come pick it up or the inventory. This is an impound for the purpose of investigative hold to get a search warrant, and that was done in a timely fashion, in a reasonable fashion. Number two, it's a vehicle, so all that's required to search a vehicle, probable cause, and I submit that based on the evidence that the court heard from the witness herself, and I think it's appropriate to take into consideration the sworn testimony and the search warrant that was not challenged, that there was probable cause to search the vehicle at the time she encountered the 7. And then finally, assuming that the challenge is to the warrant itself, if you excise out, and assuming that there's anything problematic about the seizure itself, I don't want to be that there is, but just for the sake of argument, assuming that there was, even if you excise that part out, the warrant still stands. And so for those 3 reasons, we have absolutely to the court that this was not an illegal search, that in no way were the defendant's rights violated. The tree's not poisonous, the fruit's not poisonous, and the inquiry being here asks that you deny the defendant's motion.
Before you have a seat, let me ask you, on the first part of the Reyes test, probable cause to believe that the container holds contraband of foreign evidence. What's the probable cause to believe that the truck is in there marked as contraband or evidence?
Judge, I think where we get to that is the fact that the detective had seen the defendant driving that truck to and from the Pine Grove residence. Will the Pine Grove residence, this kind of hotbed of fraud. The whole renting of that residence is based on using false identities, bad checks, theft by deception, etc. And so that's kind of thing number. Thing number two, at the time that the vehicle was seized, the detective knew that he had multiple pending charges that were dealing with stolen vehicles or fraud related to vehicles or fraud related to trailers. And so add that to the file. Number three, she testified that generally based on her training experience, she knows that these types of crimes, white collar crimes, involve documentary evidence. There was clearly cell phones involved, all of which could have contained evidence of the fraud that was taking place as it relates to Pine Grove. She testified, and that's a little bit going on with her background and experience, but it's clear that there was fraud that was taking place. We know common sense that people using a cell phone, carry documents back and forth. There were documents that specifically testified to by the detective, police themselves, cease and desist letter, et cetera, that were kind of in the sphere of this case. And then, like I said, she just testified that white collar crimes in general often have this type of documentary evidence involved. And then I guess the last part I would add on to that is she testified that she saw a suitcase, a backpack, other containers within the vehicle just by plain view at the time the defendant was pulled over and stopped. And so I think when you put all those things together, she can surveillance informant. She knows that he's going back and forth between this residence. She knows that sometimes he drives this vehicle to the residence, sometimes he drives heavily to the residence. She knows that there's only potentially stolen motorcycle at the residence. I think it's reasonable for her to believe that there's going to be evidence of these crimes that have been going on for at least a month in the personal vehicle of the defendant. He's driving when she sees him driving away from the house in question. So that's what I would submit to the court. Surpasses that very, very, very low bar of probable cause. She doesn't have to say with certainty that there's evidence there that is reasonable to believe that there would be evidence there.
Okay, anything else, Mr. Woodruff, particularly on that probable cause?
Nothing.
Sure.
What I request is that the court give us the opportunity to submit a very short brief if anything else comes to me within the 10 days or so.
All right, very well. Here is where I am. We need to take up at least the issue of the seizure of the truck. I understand the difference, and I do believe the Reyes-Castro case is very instructive. The seizure of the truck, I believe officer had a hunch that there's something in that truck, and they're not allowed to have hunches. Officer never saw any crime being committed involving that truck. Officer never saw the defendant do anything related to the crime in that truck. She never saw him deliver the bad check in that truck. The vehicle was not stolen. The briefcase and the suitcase, she never saw a document in that truck sitting on the briefcase talking about anything. She had a hunch that there's something in that truck. And I believe her testimony was such that she believed she has had a hunch, a belief that there's something in that truck. They needed to investigate what was in that truck because there could be something in there, but there could also not be something. So I think she had a hunch as to there could be something in that truck. There was no evidence to lead to any probable cause to believe that there was anything inside the truck other than the defendant was driving that truck that day. And if that truck should not have been seized under the Reyes-Castro test because there was not probable cause, then we never get that truck to the impound lot. Then the dog never incorrectly gets on the truck. Maybe the dog needs more training, maybe can't officer needs more training, but then it all pan out to incorrectly alerts on the truck, to get inside of the truck to not find the drugs, but to find other things in the truck. But I do want to read through the cases cited, but I also don't want to miss this opportunity to determine if this is a hunch, and this is for you, if this is a hunch, and the truck should have stayed there in the parking lot. If that is my ruling, then I think the real question becomes, I understand the things found in there that's in the return of the search warrant, 030244, the book bag, the silver black computer, cell phone with black and white case, iPhone with black and white cover, 32 gigabit USB drive, and the keys are all out. But then, that leads to the bigger question of where does that take us? What other evidence does the defense believe is connected to the excluded evidence? And what other search warrants does the defense believe were only gotten based on the excluded evidence? And that's kind of why I had you go through the list of things, because I do believe the state was not given proper notice of the poisonous fruit from the tree. And so I would like to hear more on what else would be excluded, and how those things are connected to the items found in the truck. Now we at least have a list of items. The search of the residence, the computers, the iPhone, those seem directly related to the truck there. The defense also believes there's some other items that might very well be excluded, but I would give the state an opportunity to bring forth evidence if they need to file a reply. I guess defense needs to file something and give the state an opportunity to file a reply. I would like to issue one order versus two separate orders. The reason being, because if I'm going to suppress some of the state's evidence, they have an absolute right to appeal. And I'll really do it in one appeal, Mr. Wolf, and take this issue up and say, okay, Judge, I know you were right on this issue. And then I could do the second issue. Because Mr. Williams is in custody, I would like to get it up one time for the Court of Appeals to tell me I'm wrong. Then go up once, they say I'm right, and go up the second time, they say I'm wrong. So if you all would, Mr. Hoover, if you would please give us a more particularized motion on the other documents and evidence that you believe is excluded from. I got the truck part, right? I got the truck part and the return of this warrant. I'm kind of with you on that, but what's the next step past the truck? You got the houses, you believe, and anything else you believe that maybe needs to be looked into. And then for the state, I want to give the state an opportunity to bring forward any other evidence, witnesses that you believe why these things are not connected to the search of the truck. And I will. I know we're about to hit a couple of week break with the holiday coming up. So we have to find one in our schedule to have another hearing. But I guess how long do you need to get something filed on the fruit of the poisonous tree evidence? I'm sorry, I looked at Mr. Hoover and I said, so Attorney Hoover, how long would you need to particularize the second one? I think you have all the information here. It needs to be time to get it together.
only because of the holidays next week. If I ate 2 weeks, it shouldn't take that long. Just because of the holidays next 2 weeks.
Okay, and that's fine, I'm gonna give you the time you asked for, but keep it in mind that, you know, we do have Mr. Williams, in custody, in the court of appeal, if they wanna look at it, they wanna, it's gonna take them some time, so, let's say, January 6th.
Oh, yeah, that's what we're talking about.
All right, so January 6th, and then the state will have theirs by the 17th, which will be response by the 17th, that's 2 weeks from the 6th.
That should be good.
And then we will, Mr. Gordon and I will, we might have to bump some civil, but we'll work to get it back in here and give you all time to continue who you need to. So Mr. Williams, I have not made any rulings at this point in time. Please continue to work with your lawyers. I want to do one order on this, and then there's a second part that I think we need to look into. I do not mean to delay your trial in any manner, but you were indicted in April of this year, and so I think we're on track to hopefully get your case resolved within a year of the indictment. All right, lawyers, are any questions, Attorney Hoover, as to where we're going from here? Any questions, Deputy Assistant District Attorney Hoover, on where we're going?
Judge, my only question is if the courts can hold off any ruling until it's all resolved. Do we also have until the 17th to file something on the issue?
Yes, you may, yes. I'll spend my time close to your evaluation.
Sure.
All right, very good. All right, everyone, thank you all, thank you.
All right, everybody. So court is adjourned for today. There you have it. So we'll talk more tonight, all right? So just join me live tonight. Make sure you subscribe to the channel, turn on your notifications, and I will send out a pre-notice before the live is set to start, okay? Thank you guys so much for being on. Love you all.
Waiting on you, ma'am.
Okay.